This is part 6. When we were discussing the negotiable instruments, namely promissory note, bill of exchange and check, there we learned that the amount for which a negotiable instrument is drawn must be certain sum of money only. At times, at the time of drawing maybe a promissory note, bill of exchange or check, it may happen that the amount stated in figures and words is different. And if you come across such a situation, then which amount has to be taken into consideration is dealt as far as section 18 of the Negotiable Instrument Act is concerned. And the heading of section 18 is where amount is stated differently in figures and words. It's very simple to understand. It says if the amount undertaken or order to be paid is stated differently in figures and in words, the amount stated in words shall be the amount undertaken or ordered to be paid. So this is the law, substantive law as far as section 18 is concerned, that when you come across a situation where the amount stated in the words and in the figures in the different, it is the amount that is stated in the words shall be the amount undertaken or ordered to be paid. That is one section to which I wanted to draw your attention. And then, as we were discussing promissory note, in which case there are two parties only, the maker and the payee of the promissory note, whereas in case of bill of exchange there are three parties. One who draws a bill of exchange, maker of the bill of exchange is known as drawer of the bill of exchange. The person to whom a direction is given or order is given is known as drawee of the bill of exchange, and the person in whose favor the bill of exchange is drawn is known as who is supposed to get the amount is known as payee of the bill of exchange. Now, if it is the situation where the person has ordered himself to pay the amount accordingly, pay to me or to my order, naturally instead of three parties you come to a situation where there are two parties only. And then by reading the bill of exchange or promise as stated, the bill of exchange or that instrument as a whole, you have to infer the intention. But it may be ambiguous instrument, and under such circumstances, now whether it should be construed as a promissory note or bill of exchange, for that it is must, no particular form of words is required. You have to read the entire instrument and then try to find out what is the intention. You have to infer the intention, and hence in case of ambiguous instruments, section 17 makes a provision, and it says where an instrument may be construed either as a promissory note or bill of exchange. So it is, as per the wording of the instrument, it says where an instrument may be construed either as a promissory note or bill of exchange, the holder may at his election treat it as either, and the instrument shall be thenceforward treated accordingly. So that is as far as what to do with respect to ambiguous instrument is made very clear as far as section 17 of the Negotiable Instrument Act is concerned. With this now we start discussing section 2 sections to which we shall be discussing. One is Section 8 of the Negotiable Instrument Act, which defines holder. And what it says, the holder of a promissory note, bill of exchange or check, means any person entitled in his own name to the possession thereof, and to receive or recover the amount due thereon from the parties thereto. So who is holder? Holder, as A draws a bill of a promissory note in favor of Mr. B, or A draws a bill of exchange in favor of Mr. C, or A has drawn a check in favor of Mr. C, then naturally in case of promissory note B, in case of bill of exchange C, and in case of check also Mr. C, these are the persons who are entitled in their name to possession. So here the section makes it very clear that one who is entitled in his own name to the possession, he may have possession or he may not have possession. During course of time you might have dealt with the concept as far as the distinction between ownership and possession is concerned. This is very important from the point of view of understanding many concepts as far as the law is concerned, and hence the person may not be having possession, but if he is entitled in his own name to the possession, that is one thing. So if he is entitled in his own name to the possession, and second requirement is that to receive or recover the amount due thereon from the parties thereto. So he has got right to receive or recover the amount due thereon from the parties thereto. Such a person is what is known as a holder of a negotiable instrument. Now in case where a negotiable instrument is drawn by A in favor of B and it is lost by him, then in such a situation, when the negotiable instrument is lost, the further part of the section says where the note, bill or check is lost or destroyed. There may be a case where it is lost or destroyed. Then it says its holder is the person so entitled at the time of such loss or destruction. So one who was entitled at the time of such loss or destruction is the holder of such a negotiable instrument. But in a case when it is drawn in favor of Mr. B, who is entitled in his name and to receive or recover the amount, and if that is found out by Mr. Z, so Mr. Z is now finder of the negotiable instrument. So now, though he is having now bill of exchange, or though he is having a negotiable instrument, he, finder, is not entitled in his own name to the possession, and hence finder of such a note or finder of such a bill of exchange or finder of such a check cannot be labeled as what is known as holder of a negotiable instrument. If the person has got it by committing theft, if he is a thief, in that case also, he cannot be, such a person is not at all a holder as far as the negotiable instrument is concerned. Now, as at the time of learning law, you must have come across Binami transactions. You want to carry out a transaction, but instead of carrying out that transaction in your name, you take name of, it is the transaction is carried out in the name of some person, what is known as Binami transaction. So if it is Binami transaction, that is explicitly barred, and the person, for example, under Binami transaction cannot. So I mean, if for the sake of convenience, if a promissory note is drawn in favor of Mr. favor of Mr. Z, so now I mean, a Mr. if it was for Mr. B cannot, when it is drawn in the name of Mr. Z, B cannot say it is a benami transaction. Actually, in fact, I mean, I am entitled. No, because what is the requirement of the section? Section clearly says the holder of a promissory note, holder of a promissory note, bill of exchange or check means any person entitled in his own name to the possession thereof and to receive or record the amount due thereon from the parties thereto. Now, if promissory note, if a negotiable instrument is drawn in favor of Mr. B, after death of Mr. B, his legal heirs will step into his shoes as far as the amount for which the negotiable instrument is drawn, and such heir becomes a holder, because now he has got right to recover the amount from the parties thereto, because as far as the law relating to succession is concerned. Now with this, now along with section 8 of the Negotiable Instrument Act, this is also the time for me to draw your attention to section 45A, which deals with holders' right to duplicate of lost bill. And it says, where a bill of exchange has been lost before it is overdue, the person who was the holder of it may apply to the drawer to give him another bill of the same tenor, giving security to the drawer, if required, to indemnify him against all persons, whatever in case the bill alleged to have been lost shall be found again. If the drawer, on the request as aforesaid, refuses to give such a duplicate bill, he may be compelled to do so. So the person, for example, holder has got right to get duplicate in case when the bill is lost, as far as section 45A. So this is also the right of the holder. We are going to take into consideration what are the rights, what are the privileges as far as holder and the holder in due course is concerned. So this is as far as section 8 of the Negotiable Instrument Act, which defines holder. With this, now we proceed to understand holder in due course. Now once we start understanding holder in due course, the first, before we start working out details as far as section 9, which defines holder in due course, is concerned, this is the time for me to draw your attention to section 118 of the Negotiable Instrument Act, which deals with the chapter is 13, and the heading of the chapter is Special Rules of Evidence. And the first, if you refer to section 118, it says presumptions. The chapter starts right from section 118 up to 122, and the section 118 deals with presumptions as to negotiable instrument. And what it says, it starts with the wording, until the contrary is proved, the following presumption shall be made. So following presumption shall be made. And to know what are the presumptions that shall be made, this is the time for me to draw your attention to section 4 of the Indian Evidence Act of 1872. And then if you refer to section 4, which defines what do you mean by, at times as a student of law, you shall be coming across various terms: may presume, shall presume, and conclusive proof. Now here it is not necessary for you to know what do you mean by may presume or conclusive proof. But then by may presume it means whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. So this is what is meant by may presume. What do you mean by shall presume, with which we are concerned as far as section 118 is concerned? It says shall presume, and it says whenever it is directed by this act. So now here it has got reference to the Evidence Act, but here also the meaning is the same. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So what the court will do? Court will regard such fact as proved unless and until it is disproved. And this is very important for the purpose of free circulation of the negotiable instruments, because of these rule of evidence. Namely, this is once you have this is for first section that first part I am referring to, but then we shall be coming again to the next part. And what is conclusive proof? When one fact is declared by this act to be conclusive proof of another, the court shall on the proof of one fact regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. So this is what do you mean when you can say it is proved, disproved and not proved, are the various aspects that you can refer to by having reference to the provisions of the Indian Evidence Act. Now, before we started discussing section 9, the time for you to refer to section 118 small g, and what it says, that holder is a holder in due course. So until the contrary is proved, the following presumption shall be made. So what is the presumption that is made? The presumption is that the holder of a negotiable instrument is a holder in due course. So this is very important, because now during course of time we will understand the importance of the concept of holder in due course. A holder in due course is entitled to recover amount from any one of the prior parties. That is one thing. And once you can label that he is a holder in due course, naturally it cleans off all the defects, and then even though he has received that negotiable instrument whose title was defective, the title of the holder in due course becomes clear. It cleans off all the defects. So this is every holder, that the holder of a negotiable instrument is a holder in due course. Of course, it is subject to proviso, which says provided that where the instrument has been obtained from its lawful owner, or from any person in lawful custody thereof by means of an offence or fraud, or has been obtained from maker or acceptor thereof by means of an offence or fraud, or for unlawful consideration, the burden of proving that the holder is a holder in due course lies upon him. This is the only proviso, otherwise it's not necessary for him to prove every holder. So that the holder of a negotiable instrument is a holder in due course, and hence once he is a holder, so when holder can be a holder in due course, holder can be holder in due course when the case falls under section 9 of the Negotiable Instrument Act. There are some other sections as far as this chapter is concerned to which I shall be drawing your attention during course of our lecture, namely section 120, section 121 and section 120. but this is a part with which we shall be dealing after some time. Let me first of all come to section 9 of the Negotiable Instrument Act. And what is section 9 of the Negotiable Instrument Act? We are discussing the concept of holder in due course, and it says holder in due course means, who is holder in due course? It's holder in due course means any person who for consideration became the possessor of a promissory note, bill of exchange or check, if payable to bearer, or the payee or endorsee thereof if payable to order. So this is first part. So he can be a bearer of the instrument, yes. He can be payee, or as during course, when we started discussing the importance of the Negotiable Instrument Act, there we had learned that the first person who gets it is a payee. And what he can do, he can put it into circulation. So now, if the payee has put it into circulation, so he can be one, he can be, as I told you, if nobody's name is mentioned or there, he can be a bearer, when the negotiable instrument can be drawn to the bearer of it, or he may be a payee or he may be endorsee thereof. And there the negotiation of a negotiable instrument with which we shall be dealing during course of our lecture, we will learn that one, it depends upon the nature of the instrument. If it is a bearer instrument, it can be negotiated by delivery, but if it is an order instrument, there is the person has to make an endorsement, and then there must be a delivery after endorsement is made. What endorsement, you sign on the back of the negotiable instrument, and what is written above the signature, that is, there are different kinds of endorsement with which we shall be dealing. That is a part as far as the procedural aspect is concerned. We will come to it. This is just introduction. So now, when he can be a holder in due course, means any person who for consideration. So one who became the possessor of a promissory note, bill of exchange or check if payable to bearer, or the payee or endorsee thereof if payable to the order. So without consideration, if he has got that negotiable instrument without consideration, such a person cannot be a holder in due course. And then coming back to section 118 as far as small a is concerned, it says, firstly it starts with consideration, and it says that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. So there is a presumption, until the contrary is proved, this presumption shall be made that he has become, when he is a bearer, when he is a payee, when he is an endorsee, he has got that negotiable instrument for consideration. Now I don't think it's a time, because I have told you in the past that whenever when we talk about consideration, yes, naturally you will have to refer back to understand what do you mean by consideration, with which everybody might have already dealt when you dealt with the provisions of the general principles of the contract, right from section 1 up to section 75 of the Indian Contract Act. But the first requirement is that he must he must have got that negotiable instrument for consideration is the first ingredient, so that he can become what is known as holder in due course. Now secondly it says when he can become a holder in due course, this negotiable instrument can remain into circulation when it becomes mature, till it becomes mature. It can remain into circulation after maturity, because unless the payment is carried out or it has been satisfied, that can remain into circulation, no doubt about it. But in order that he should be what is known as holder in due course before the amount mentioned in it became payable. So unless that amount becomes, before he, in other words, he can become a holder in due course. First thing is that he must have got that negotiable instrument for consideration before the amount mentioned in it become payable, which does mean that he has got negotiable instrument before maturity. Now, whether for the purpose of understanding before maturity, this is a time for me to draw your attention to few sections as far as the Negotiable Instrument Act is concerned. The first section to which I want to draw your attention to section 19, which says a promissory note or bill of exchange in which no time for payment is specified and a check are payable on demand. So these are the negotiable instruments where no time for payment is specified. So you must have been, how you can understand before maturity? What do you mean by before maturity? At the maturity, when the negotiable instrument becomes mature, the payment is required to be carried out. So now we have to try to understand what do you mean by maturity of a negotiable instrument. So if nowhere it is mentioned, if it is mentioned that negotiable instrument is payable after 1 year, negotiable instrument is payable after, barring check, because in case of check is always, if you refresh your memory as far as the definition of check is concerned, which is check is a bill of exchange drawn on a specified banker not expressed to be payable otherwise than on demand. The positive form of it is check is always payable on demand. And because of the fact that the check is always payable on demand, naturally, if you draw check today and put on a date after 3 months or 2 months date, that cannot be. Apparently it sounds that it is a leaf of a check, no doubt about it, but that is not at all a valid check, because the check is always payable on demand. If on that day you got a check, so if the date is the 5th of December and you got a check and on which the date 5th of January 2013 is written, naturally that cannot be a valid check, for the simple reason that will become a valid check only on the 5th of January, the date on which it is made payable, otherwise not. And hence now, when no time has been mentioned, no time for payment is specified, it may be a promissory note, it may be a bill of exchange, or it may be a check. In that case, what you say, are payable, these are all payable on demand. Now promissory note payable on demand, bill of exchange payable on demand, and then along with this, now this is a time for us to, in order to understand before maturity, we have to deal right from section 21 up to section 25 of the Negotiable Instrument Act, so that you can understand, or if you want to claim yourself that you want to become a holder in due course. And as I have told you in the past, again I repeat, if you become a holder in due course, then you have got right. It is only your state of mind that shall be taken into consideration by the court of law, and once the court comes to the conclusion that you are holder in due course, you have got every right to get amount. Yes, you have got every right to claim amount with respect to the negotiable instrument, and hence this is the time that unless, when you want to get the negotiable instrument, you must be in a position to know whether you are receiving that negotiable instrument before maturity or not. And to know this now, when the negotiable instrument becomes mature and rest of the details we have to deal right from section 21 up to section 25, with which we shall be dealing for the purpose of understanding that a person can become a holder, otherwise mind well. If he has got a negotiable instrument after maturity, he can be a holder. If he is a holder, he will have the same rights as that of a transferor. But if he becomes a holder in due course, then as I have told you, that is an exception to the maxim nemo dat quod non habet, with which we shall be dealing during course of our lecture. And then further part, so we are going to discuss what do you mean by before maturity, and further part of the section says, and without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. So now his state, whether he was honest or not, that we have to, we shall be taking into consideration. It's not question whether he was negligent or not, as it is specifically expressly mentioned as far as section 10 is concerned, with which we shall be dealing in during course of time when we try to understand what do you mean by payment in due course. Here it's not that, but what it says, without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. So now this is the time for it when you want to claim yourself to be holder in due course. You receive a negotiable instrument, but what should be the negotiable instrument? It must be, as we say that it is a you must receive the negotiable instrument, it must be complete and regular. So unless it is complete and regular, and what do you mean by complete and regular? If it is a promissory note, it must fulfill all ingredients of section 4. If it is bill of exchange, it must fulfill all ingredients of section 5. And if it is a check, it must fulfill all ingredients as per as section 6, which defines check. So now what do you mean by before maturity? And then the last part as far as this section is concerned, section 9 is concerned. And then what are the rights and privileges as far as holder in due course is concerned, with which we shall continue our discussion as far as next part is concerned.